Good morning everyone. Myself Seji and Dr. Seema Rathi from School of Law and Legal Studies, Sage University, Bhopal. My today's video lecture is on matrimonial remedies under Hindu Marriage Act 1955. Matrimonial remedies are defined from section 9 to 13 of the Hindu Marriage Act 1955. The marriage in the Hindu jurisprudence is a sacrament. The Shastric Hindu law didn't know the terms of divorce, restitution of conjugal rights, and judicial separation. These terms have been incorporated in the Hindu Marriage Act 1955 by the influence of the English law. All the matrimonial proceedings are conducted in camera, that is, only the judge and spouse present in the court hall. Other parties and advocates are not permitted in such in-camera proceedings. Camera proceedings are conducted on the application of neither spouse. The judicial matrimonial remedies mentioned hereunder have been provided in the Hindu Marriage Act 1955 to the parties to an unhappy marriage. They are restitution of conjugal rights, section 9, judicial separation, section 10, nullity of marriage. It includes both void marriages and voidable marriages. That is defined from section 11 to 12. Next one is divorce, section 13. Another one is alternate relief in divorce proceedings, and the last one is divorce by mutual consent. That is defined under section 13 subclause B. So first is restitution of conjugal rights. Restitution of conjugal rights is a hope of getting nearer both the spouses and avoids conflicts. It's a ray of hope. It's a last resort to establish amicable relations between them. Sometimes the wife and husband may live separately due to conflicts. The decree of restitution of conjugal rights may bring them together and get them united, which is the object of the marital life. As per section 9 of the same act, when either the husband or the wife has, without reasonable excuse, withdrawn from the other, the aggrieved party may apply by petition to the district court for restitution of conjugal rights, and the court, on being satisfied of the truth of the statements made in such petition and that there is no legal ground why the application should not be granted, may decree restitution of conjugal rights accordingly. Second, that is judicial separation, section 10. Section 10 of the Hindu Marriage Act 1955 provides that judicial separation to the parties to a marriage. The grounds for the judicial separation are similar with those of the divorce under section 13 enunciated in that section. The judicial separation does not put an end to the marriage. It temporarily allows the parties to the marriage to live separately. Sufficient time can be available to both the spouses to think over so that each of such parties may release his or her fault. The Hindu marriage is regarded as sacrament. It is not a contract. The Hindus believe the marriage as most sacred. More particularly, the Hindu woman doesn't like to have divorce. The divorce on one side puts the end of matrimonial life, and on the other side, it causes humiliation to the divorced woman in the society. Grounds for the judicial separation. The other spouse had voluntarily sexual intercourse with any other person. The other party treated the petitioner with cruelty. One spouse deserted the other spouse for a continuous period of not less than 2 years immediately preceding the presentation of the petition. The other party converted his or her religion. The other party became the person of unsound mind. The other party has been suffering with incurable leprosy. The other party has been suffering from venereal disease. The other party has not been heard from the last 7 years. In judicial separation, court gives permission to get separate. It permits the parties to a marriage to live apart. If this decree is passed by a competent court, it is not obligatory for either party to make sexual relations to each other. The decree of judicial separation does not put an end to the marriage. It temporarily allows the parties to live separately, and their mutual rights and obligations arises from the marriage are suspended, so that each of such parties may release his or her fault. Thus, judicial separation either leads to reconciliation or to divorce. Next is, third point is nullity of marriage, that is defined under section 11 and 12. Void and voidable marriages. Section 11 and 12. Void and voidable. There is a lot of difference between these two terms. Void means an instrument or transaction is so nugatory and insufficient, ineffectual, and it cannot be cured by any means. Voidable means that wherein an imperfection or defect crept in an instrument or transaction can be cured by subsequent act or confirmation by the parties who could take advantage of it. A void marriage is a void ab initio from the very beginning. For example, a marriage between the parties who are in prohibited degree is void ab initio. A voidable marriage is valid until is set aside. The voidable marriage can be set aside only by the parties to the marriage approaching the court of law. The application to the district court must be submitted within the period of limitation prescribed. Void marriage. Section 11 provides about the void marriage, which can be declared as nullity of marriage if any of the spouse approaches the court of law. Relation between section 5 and section 11. Section 5 narrates the 5 conditions for a Hindu marriage. If these conditions are not followed in a Hindu marriage, such a marriage becomes null and void. Conditions. 5 conditions are mentioned in section 5. If these 5 conditions are fulfilled, such a marriage becomes valid. If these 5 conditions are not followed and fulfilled, such a marriage becomes nullity of marriage and void. Grounds of void marriage. Section 11, grounds of void marriage. That is bigamy, which is defined under section 5 subclause 1. Another is marriage in prohibited relationship and no custom to support, that is defined under section 5 subclause 4. And marriage in Sapinda relationship and no custom to support, that is defined under section 5 subclause 5. Now voidable marriage, that is defined under section 12. So section 12 deals with the rule regarding voidable marriage. As per section 12, any marriage shall be voidable and may be annulled by decree of nullity on any of the following grounds, namely, marriage has not been consummated due to impotency of the respondent, unsoundness of mind, consent of the petitioner has been obtained by force or fraud, pre-marriage pregnancy of the respondent by some other person other than the petitioner. Avoidable marriage is valid until is set aside by the competent court of law. Next is divorce. That is defined under section 13. We will discuss this topic in the next video lecture in detail. Thank you.